So it is my great pleasure to introduce our keynote speaker, who's known to many of you, Bob Percival. Bob is the Robert Stanton Professor of Law and the Director of the Environmental Program here at Maryland Law School. Bob has an illustrious resume, which I will briefly give you the highlights of. He received his BA summa cum laude from Macalester College. He attended Stanford Law School. He also has an MA in economics from Stanford University. Along the way, he received the prize for graduating first in his law school class. Following graduation, he clerked on the U.S. Court of Appeals for the Ninth Circuit, then for Justice White in the Supreme Court, and he joined the Maryland faculty in 1987 after serving for several years with the Environmental Defense Fund. He is the author of the leading environmental law textbook. But the real question about Bob is he more partisan to the National League or the American League? And how does he get so much done, given how much time he spends traveling back and forth to China? So, Bob.
Thank you, John. I actually am a huge National League Baseball fan now that we have the Washington Nationals, because I live on Capitol Hill. But unfortunately, there was the most pernicious possible taking this week because the Baltimore Orioles took away the remaining fading hopes the Nationals had of making the playoffs by sweeping them 3 straight. I was not the first choice for a keynote speaker. I was sort of the default speaker. John said, try to come up with a provocative title, so I came up with this title. Some of you were kind of asking, what's the plastic trees business? And Lawrence Tribe in 1974 in the Yale Law Journal published this famous article, Ways Not to Think About Plastic Trees, where he advocated for creating a new environmental ethic that was not entirely human-centered. He had been inspired by the announcement by the city of Los Angeles that they were going to start installing plastic trees in medians for the highways where natural trees could not be grown because there was not enough soil. And the argument that he made was not that this was a huge environmental problem, but that he wanted to resist the notion that we could replace nature with things that looked like nature. In this article, he actually advocated for developing a new environmental ethic, explored some of the contours of what that might look like, and it was widely hailed as a real breakthrough in the nascent field of environmental law and environmental ethics. And in fact, when I, in 1997, put together an anthology for Temple University Press of the best work in environmental law, I included it in the environmental ethics section. I also included some of Carol Rose's work in this as well. In addition to being an early advocate of environmental laws development, Professor Tribe then became a great constitutional law scholar. The year I was clerking on the Supreme Court was the year he argued his first case in the Supreme Court, the Richmond newspaper's First Amendment case, and he wrote the casebook on constitutional law that became incredibly popular. And by agreement of virtually everyone, he's an absolutely brilliant scholar who had a distinguished track record in the field of constitutional law and then in environmental law. Now, fast forward to today, last December, this op-ed appeared in the Wall Street Journal from Professor Tribe, where he's declaring that EPA's new Clean Power Plan is unconstitutional. And he doubled down on this well, of course, the Wall Street Journal was hailing this as finally President Obama is exposed because his former constitutional law professor says that his EPA is doing something that clearly violates the Constitution. And he doubled down upon this in a congressional hearing in March, where he came up with the phrase that the Clean Power Plan is like burning the Constitution. In fact, he said burning the Constitution should not become part of our national energy strategy. This was so beloved by the Republicans that before the hearing was even over, as Professor Revesz of NYU pointed out in a subsequent op-ed in the New York Times, they were tweeting the burning the Constitution line even before the hearing was ended. And the first I heard about this, I actually was in China last December, and I got an email from my friend David Doniger at NRDC saying, have you heard the latest about what Professor Tribe's up to in saying the Clean Power Plan's unconstitutional? And he said, why don't we write letters to the editor of the Wall Street Journal? And I said, well, what I want to point out to the Journal is this is not a huge new development that Professor Tribe is saying environmental law is unconstitutional. He's been doing this for decades on behalf of industry groups. So what's the big news here? It's not that suddenly someone who believed that everything EPA was doing was great has turned around and decided that there's been a revolutionary change at EPA. For example, in 2000, when the Supreme Court heard the Whitman versus American Trucking case, it was a challenge to the tightening of EPA's ozone standard, and General Electric hired Professor Tribe to write a brief supporting the DC Circuit's 2-to-1 panel decision that had struck down the Clean Air Act's provisions for setting national ambient air quality standards on the grounds that they violated the non-delegation doctrine. And Professor Tribe filed this brief where he said that in all his years as a constitutional law professor, he's never seen better grounds for reviving the dormant non-delegation doctrine. And in fact, there had only been 2 cases in the Supreme Court, both in 1935, when the court was hostile towards the New Deal programs, where the non-delegation doctrine had been used to strike down congressional legislation. In fact, when I teach constitutional law in my constitutional law class, I ask my students the following baseball question: why is the non-delegation doctrine like Mark the Bird Fidrich? And the answer is because it only had one good year. Fidrich was the Rookie of the Year in 1976. He spent the month of April in the minors, but came back, won 19 games, and this is what blows me away. He had started 29 games, pitched 24 complete games, but then he got hurt and was never a star again in the majors. So the fact that Professor Tribe would argue that a doctrine that had been dead for over 6 decades should be resuscitated because EPA was tightening its ozone standards, with the implication that the whole Clean Air Act is unconstitutional as a result, was really quite extreme. And when the case got to the Supreme Court, even though the industry lawyers thought they had 5 votes for this position, what they were really trying to do was get the court to construe the Clean Air Act narrowly as requiring cost-benefit analysis, even though throughout its history, the DC Circuit had held that it did not permit consideration of costs when national ambient air quality standards were set. A counsel for industry said, we just can't live with a statute like this. But Chief Justice Rehnquist said that you say you don't know how we can live with this kind of regime. Well, we've lived with it for 20 years. What's the big deal? Now you want to upset all our major Clean Air Act regulations by getting us to go back 60 years to revive this doctrine. So it was no surprise after the oral argument when the Supreme Court unanimously rejected the non-delegation argument in an opinion by Justice Scalia that said the courts never demanded a determinate criterion for telling EPA exactly how stringently it should regulate, and that the Clean Air Act is well within the outer limits of our non-delegation precedents. So that was the non-delegation argument. Then GE hired Professor Tribe for a series of cases that lasted over a decade where he was trying to get the Comprehensive Environmental Response, Compensation, and Liability Act, better known as the Superfund Law, declared unconstitutional as a violation of due process. GE had been ordered to clean up PCB's its companies had released in the Hudson River, and it was going to be real expensive, so they wanted to be able to go to court to stop that. Under the statute, it barred pre-enforcement review, so they had a choice of either obeying the cleanup order or risking treble damages against them, and Tribe said, CERCLA is an Alice in Wonderland regime of punishment first, trial afterwards, even in a non-emergency setting. This offends the Constitution. And of course, once again, because it was liberal legal icon Lawrence Tribe, Forbes magazine said Al Gore's lawyer is trying to get the Superfund law declared unconstitutional. This is a big development. Well, ultimately, the DC Circuit unanimously ruled that there was no constitutional problem, and the US Supreme Court did not even see fit in this case to grant cert. So now we have the Clean Power Plan, and I wanted to take a look at the argument he was making that because EPA is issuing regulations applicable to existing power plants in order to control their greenhouse gas emissions, that somehow this has resulted in a regulatory taking that requires that the coal industry be compensated. He cites the fact that John F. Kennedy and Hillary Clinton in 2007 said coal's a big part of our economy, as somehow creating investment-backed expectations that EPA would not adopt regulations that would reduce the demand for coal by power plants. There should be no mistake about how radical EPA's proposal to phase out the use of coal to generate electrical power actually is. And he cites Secretary of State Kerry at the time as saying, we're going to take a bunch of coal-fired power plants out of commission. Well, an awful lot of coal-fired power plants should have been reaching the end of their useful life. Unfortunately, Congress made a big mistake in the 1970 Clean Air Act in grandfathering in a lot of the existing plants so that they did not have to install new pollution controls unless they made major modifications. And so a lot of utilities just sort of rebuilt them from the inside out to keep them operating as long as possible without the scrubbers that a modern plant would have. Tribe argues that when regulating an entity out of existence generates diffuse benefits for the public at large that exceed the targeted costs imposed on the unlucky few, the Fifth Amendment's basic teaching is that the few should be justly compensated by the many. What's really sort of at the root of his argument is the notion that CO2 is not really a pollutant that harms people. This is not a case of traditional air pollution in which the government targets emissions that are in themselves harmful to those exposed to them. CO2 simply is not a pollutant in the conventional sense. Any injuries associated with climate change stem only from the overall worldwide concentration of carbon dioxide, irrespective of source. This is precisely the kind of situation in which the government bears a constitutional obligation of compensation. Now, the response to Professor Tribe from the Environmental Law Professorate has not been very kind, and his colleagues, Professors Jody Freeman and Richard Lazarus, have written a particularly harsh response where they call it ridiculous, wholly without merit, preposterously extreme, and radical. And they argue that the clear implication of Tribe's novel view of the Fifth Amendment is that the coal industry and the power plants that burn their coal possess an absolute constitutional property right to continue to emit greenhouse gases in perpetuity. No Supreme Court opinion has ever announced such a preposterously extreme proposition of constitutional law, nor has even one single justice in the more than 2 centuries of cases endorsed such a reading of the Fifth Amendment. Tribe has replied to this by arguing that my point's always begun with the proposition that despite the well-known rule cited by Professors Freeman and Lazarus, that the restrictions on harmful emissions do not ordinarily require the government to pay industry to stop polluting, what EPA seeks to do here by targeting particular energy plants for extinction is uniquely arbitrary, both because of the ubiquity of CO2 emissions and because of the massive investments EPA has required these very plants to make in anti-pollution control efforts over the past quarter century. In a sense, what he's arguing is the same argument that was made unsuccessfully by the industry groups in Massachusetts versus EPA, where they argued that CO2 is not a regular pollutant and therefore it shouldn't be regulated under the Clean Air Act. My colleagues seem quite sure the Supreme Court would require no compensation here. In truth, none of us can be confident either way, but from the outset I've stressed that the rule of constitutional avoidance cannot mean that courts must resolve constitutional questions in order to avoid answering them. As long as the questions are substantial, as this one surely is, courts have applied the avoidance rule by, for example, striking down regulations that raised Fifth Amendment concerns without actually having to decide the Fifth Amendment issue. And I submit this is really what's going on here. The idea was, let's pile on so many possible legal and constitutional objections that we might be successful in convincing a court to throw up its hands and say, let's just strike down the rule so we can avoid this. This has been a technique you've seen most successfully used in wetlands cases, cases like Swank and Rapanos, where the court said, in order to avoid constitutional issues of whether the federal government's gone too far, we're going to narrowly construe the Clean Water Act with respect to what's covered by federal regulation. In their rebuttal to Tribe, Professors Freeman and Lazarus say that we're pleased to see in our colleague's response a quiet yet unmistakable retreat from his earlier pronouncement that the Clean Power Plan is an unconstitutional taking of property in violation of the Fifth Amendment. All that could be mustered, presumably upon further reflection, is that EPA's proposal would run right up against the Fifth Amendment and would thereby require any reviewing court to resolve yet another tough constitutional question. There's no plausible taking here. Now, Professor Tribes was hired as part of a legal strategy to defeat the Clean Power Plan, and at its most radical aspect, the companies decided that they were going to sue EPA before it had even completed its rulemaking to issue the Clean Power Plan. So they filed a petition for review in the DC Circuit in fall of last year. I was teaching administrative law at the time, and I asked my class, what's going to happen to this? And they said, well, there's no final agency action until they issue the rule. Why are they suing? And then they said, why is the DC Circuit even granting them oral argument in this case? And there was a Nebraska district judge that just threw it out right away, saying fundamental principle of administrative law, you can't sue until there's final agency action. The argument that Tribe and the other lawyers made was that what EPA's doing is so illegal and so unconstitutional that this justifies the court in breaking the normal rules. We should use the All Writs Act because EPA's doing things that are going to be so harmful to the coal industry. And the petitioners actually ended up getting their dream team of 3 judges in the DC Circuit, the 3 judges most hostile towards environmental regulation, Judges Griffith, Henderson, and Kavanaugh. They heard oral argument on this case. Tribe did part of the argument, but quite quickly they came down with an opinion confirming that my administrative law students were correct. There was no final agency action, and they weren't going to start using the All Writs Act so that industry groups could sue anytime there's a regulation in the works that might displease them. Now, the coal industry is not going under, particularly not worldwide. This recent article in Science magazine pointed out that particularly in foreign countries, there's a total of about $550 billion in annual subsidies given to fossil fuel industries, and that's one of the reasons why there's so much demand for coal worldwide. So it's not going to go the way of the typewriter industry. There's this wonderful museum in Shanghai, China, where I spend a lot of time. It's actually the place Lawrence Tribe was born. And it's a museum of typewriters, an entire industry that you no longer see because of technological change. It is indeed the case today that there are 3 times more people employed in the solar energy industry than in coal mining. The economy is shifting towards greener energy. And just this week, the University of Notre Dame announced that it's going to phase out coal. Why? Because this is a direct response to the papal encyclical Laudato Si, where the Pope says we should be doing everything possible to reduce greenhouse gas emissions. So I think it's only, we have to anticipate that the demand for coal, hopefully, will go down worldwide in the future. Now, finally, many people have attacked Professor Tribe's motives. They said he sold out to the highest bidder, and he's just doing this for money. New Yorker had an entire piece on this quite recently. I don't want to question his motives, but I do want to note that he said that he's not just acting as a normal legal advocate on behalf of a client and taking whatever positions might benefit them, that he's doing an independent analysis of EPA's proposal as a scholar of constitutional law. When pressed by a reporter, he said that he personally agrees with his arguments on behalf of Peabody. I agreed to accept Peabody as a client only on the condition that I'd continue to speak my mind, even if not everything I'd say would be to Peabody's liking. But of course, everything he said has been to Peabody's delight. I thought long and hard about what's going on here, and this is the closest analogy I can find. Who is it that makes outrageous statements, engages in extreme hyperbole in order to get public attention, and then I think the most discerning analysis of Donald Trump's presidential campaign was actually done by a Washington Post reporter, David Fernhold, who said he was trying to discern some consistent platform in Trump's statements. And all he could come up with was the following headline: "Because I said so." And that seems to me what's going on here, because the coal industry has now as an advocate someone who has long been a very respected constitutional law scholar, who has supported liberal politicians, and who many, many years ago, Richard Lazarus actually tells me he researched it, and the last time Professor Tribe taught an environmental law course was in 1971, 1 year after the adoption of the Clean Air Act, at one time an environmental scholar as well. Now, as you've seen in the various presentations in this conference, and the fact that this conference thrives from year to year, takings issues are never going to go away. We live in a dynamic economy where there's always regulatory change, where industries come and go, and there's always going to be a huge economic incentive for companies to argue that something should be considered a taking in order to get a regulation relaxed or to obtain compensation. So the fact that you can get such windfalls that in the Palazzolo case, Justice Scalia said, better that it go to some speculative investor than to the government as thief, there's always going to be economic pressure to create new theories of takings and to litigate takings issues. So that's why I think takings issues will outlive plastic trees. But I should note, we now do have plastic trees. These are all plastic trees. You know what they are? Cell phone towers. Something could not have been anticipated when Tribe wrote his famous article in 1974, but are things that I don't think anyone's all that concerned about because they do tend to look a little better than the naked cell phone towers. Thank you.